What is constitution and constitution law? A constitution means a document having a special legal sanctity which sets out the framework and the principal functions of the organs of the government of a state and declares the principles governing the operation of those organs. There is no hard and fast definition of constitutional law. In the generally accepted use of the term, it means the rule which regulates the structure of the principal organs of the government and their relationship to one another and determines their principal functions. The rules consists both of legal rules in the strict sense and of usages, commonly called conventions, which without being enacted are accepted as binding by all who are concerned in the government. Many of the rules and practices under which our system of government is worked are not part of the law in the sense that their violation may lead directly to proceedings in a court of law. Though the constitutional lawyer is concerned primarily with the legal aspects of the government, there is required for a constitutional lawyer some knowledge of the salient features of constitutional history and of the workings of our political institutions. Historical background: all the constitutions are the heirs of the past as well as the testators of the future. The very fact that the Constitution of the Indian Republic is the product not of a political revolution but of the research and deliberations of a body of eminent representatives of the people, who sought to improve upon the existing systems of administration, makes a retrospect of the constitutional development indispensable for a proper understanding of this Constitution. No one will deny the truth of the above statement that if anyone seeks to study the law, constitutional or other, of a country, knowledge of the historical process which led to its present form is indispensable for correct insight and understanding of the subject. It is, however, not necessary to go to any period beyond what is known as the British period, for the modern political institutions originated and developed in that period only. The political institutions established by the Hindus in the olden days and by the Muslims in the medieval period have become a thing of the past, and they do not survive in any form in the present day. The British period in the history of India began with the incorporation of East India Company in the year 1600 in England. Now, let us see the various phases of the growth of our constitution from the advent of the English on Indian shore till this day. We can broadly divide the period as follows. 1600 to 1765, the coming of the British. The Britishers came to India in 1600 as traders in the form of the East India Company. Attracted by the stories of the fabulous wealth of India and fortified by the adventurous maritime activity of the Elizabethan era, Englishmen were eager to establish commercial contacts with the East. To facilitate such a venture, some of the enterprising merchants of London formed themselves into a company. The company secured for it a charter from Queen Elizabeth in December 1600, which settled its constitutions, powers and privileges. The charter vested the management of the company in the hands of a governor and 24 members who were authorized to organize and send trading expeditions to the East India. It had authority to keep an armed naval force for its security. The charter was granted in the first instance for 15 years and was terminable on 2 years' notice. It could be renewed if the interest of the Crown and the people were not prejudicially affected. The charters of 1601 granted to the governor and company the power to make, ordain and constitute such and so many reasonable laws, constitutions, orders and ordinances for the good governance of the company. The legislative power of the company was very limited in its scope and character. They were not to be contrary to the laws, statutes or customs of England. The power conferred under the Charter was essentially a power of minor legislation prohibiting any fundamental change in the principles of English law. It was not a power to legislate for some territory because the company was purely a trading concern and not a political sovereign acquiring foreign territory. The legislative power was thus designed to enable the company to regulate its business and to maintain discipline among its servants. Though limited in scope, but the legislative powers of the company was of great historical importance as it is the germ out of which the Anglo-Indian codes were ultimately developed. By the charters of 1609 and 1661 similar powers were affirmed. The Charter of 1693 makes no mention of legislative powers. The Charter of 1726 had a great legislative significance. The legislative power was vested in the Court of Directors in England. Accordingly, the Charter authorized the Governor and Council of the three presidencies to make, constitute, and ordain bylaws, rules and ordinances for the good governance of the company and to impose punishments for their contravention. These bylaws, rules and ordinances, and punishments were to be responsible and not contrary to the laws and statutes of England, and they were not to be effective unless approved and confirmed in writing by the company's Court of Directors. The Charter also established the Mayor's Courts at Calcutta, Bombay and Madras and expressly introduced English laws into these presidencies. But the Britishers had not become a ruling power in India until the second half of the 18th century. It was still a trading concern. Thereafter, events of great importance took place in the interior of Bengal. It was a period of gradual disintegration of the Mughal Empire. Its last strong emperor Aurangzeb was dead. Soon after the death of Aurangzeb, the controlling and powerful unifying force that existed in country under the rule of Aurangzeb declined and India became a battleground of rival contesting principalities. The East India Company took full advantage of this chaotic situation and gradually established itself as the unrivaled master of the Indian subcontinent. 1765 to 1858 beginning of the British rule. 1858 to 1919 end of Company's rule. 1919 to 1947 introduction of self-government. 1947 to 1950 the framing of the new constitution.